My name is Greg Barnhart, and I'm a partner at the West Palm Beach law firm of Searcy, Denny, Scarola, Barnhart, and Shipley. Let's talk about will contests. What is a will contest? Well, there are three ways where a person can set aside a will and go back to the original plan that the person who died had. So if a person is cut out, and usually it's the children of a first marriage in favor of someone else. If a person's cut out, they can bring three kinds of will contests. The first is that the decedent, the person who died, didn't do it right. They didn't meet the formal requirements, and they either did or they didn't. And that's a very simple question to answer. The other two areas, though, are where you hear about the big will contests. And that is the lack of testamentary capacity and undue influence. Lack of testamentary capacity, what is that? That means that the person who was dying, or the person who made the will, didn't have their ducks in a row. They didn't understand what was going on. They didn't have the mental and physical ability to go through the will process. They didn't understand what they had. They didn't understand who their family was. They were not competent to enter into a legal document. That's a tough one to show, but it can happen. The third, though, is the most sexy, and that is undue influence. Now, I must say, undue influence and lack of testamentary capacity tend to go hand in hand in most will contests. Undue influence means that a person in a confidential relationship, that is a person who's close to the decedent, close to the person who was making the will, procures the will and exercises their influence to an extent that they overcome the willpower and the deliberateness of the person who's dying. So how can that happen? Well, there are presumptions, and a presumption of this is that if a person is with someone in their dying days and they procure the will, that is, they hire the lawyer, they generate the formation of a will, they stand to gain, and they do gain, to the exclusion of other people, then there's what's called a pretty good case for bringing a will contest for undue influence. Now, that doesn't mean that you can't cut out a child. You can, if you want to make a will. But if you can show that the reason the child, an adult child or a small child, was cut out was done by someone else who stood to gain and did something wrong, then you can set aside a will. And so what happens if you set aside a will? Well, you go back to either the prior will, the will which was in place before this one was drawn, or you go back to the laws of inheritance. And those take care of spouses and surviving children. So if something like that happens, if there is an estate where something untoward takes place, where something looks fishy, then you may very well have a will contest, or at least grounds to bring a will contest. Thank you.